So there's a lot of evidence that needs to be determined by experts that wasn't presented in trial. And I think that the Fifth Court of Appeals has said that there's property diligence issues that need valuation.
Okay, what I received from the Court of Appeals last, I believe yesterday, I received, it was at 5:40 p.m. They denied your request for continuance.
Yes, ma'am, and the reason it did is because the motions that I have filed have not been verified. The only motion that has been verified through the clerk's office is the denial of the motion for continuance.
Okay, that's not what they said. They said, your petition didn't comply with the Texas Rules of Appellate Procedure, and they listed out the rule. And then they also said that you failed to show that the trial court clearly abused its discretion and that relator lacks an adequate appellate remedy. And then they also say that you failed to demonstrate entitlement to mandamus relief. That's what they said.
That's correct. My understanding of that is because we were not able to submit verified orders.
Okay. Well, I'm proceeding because the Court of Appeals, that's, I guess you can say, like my boss. They tell me what to do. And they told me that I needed to have another trial on property division. They didn't mandate me to make sure that any type of, what did you just say? Any further discovery. They didn't mandate me to do anything like that. They didn't authorize me to extend any type of deadline. So I'm just doing what I'm told to do. They gave me a mandate to do that. So we're proceeding with trial today. So you don't have any exhibits, just so we're clear.
That's clear. And I just want to respectfully preserve my previously filed objections to the trial setting, the denial of my continuance, and my vote.
Sorry, real quick, can I make sure that nobody's recording? I know there's a camera up earlier, make sure no one's recording in before right now.
A camera earlier. And Judge Lee?
No, here, I don't know if Ms. Chase's mother was, she had thrown up like this, if she was proceeding, I just want to make sure it's not going on.
So I'm sorry, I was interrupted, but I want to respectfully preserve my previously filed objections to the trial setting, the denial of my continuance, and my Rule 245 objection. So those were never, or the orders were never verified. I was told that my jury demand and my acceptance, or my motion to accept jury demand, the orders would be entered last Wednesday, and they were not. And the acceptance of jury demand and the jury demand orders still have not been entered to this day.
I'm not tasked for anything with the jury demand for today. I'm only required to do what the Court of Appeals tells me to do. If I do anything beyond what the Court of Appeals tells me to do, I get in trouble.
I'm objecting. This is a process, my constitutional right.
Okay, so noted, and it's still denied. So we're going to proceed. Joy, you ready? We're not on record yet. I didn't call the record. And no, and we're not going to do that. We're not, you don't get to say what you're going to call on the record. The Court of Appeals has already, what you're trying to argue before me now. Excuse me, don't interrupt me. The Court of Appeals has already said no to today. Anything you want to do after today is your business. But in terms of today, I would like for you not to interrupt me. That's the first thing. Moving forward, we are going to proceed with this hearing. I'm not going to further delay anything. As I've stated before, I was given very specific rules and directions from the Court of Appeals. That's who tells me what to do. They did not authorize me to go behind them after they have denied your request to go further. So I want to make sure that we're clear before we go on the record. I'm not entertaining it.
I respectfully would like to preserve my right to TRCP 245 and my right for a motion for a review of motion for continuance and a review of jury demand and a verified order entered for jury demand and my motion to accept
You said that once and I said no, and we're not on the record yet. I just want to make sure that before we go on the record, you understand the rules. I'm not entertaining it. I will go right back off the record.
I'm sorry, I'm representing myself per se.
And that's fine. You have to follow the rules just like everyone else. Your motion for continuance, ma'am, has already been denied. It has already been denied. You do not get to come before me and argue it again. Nobody does that. You're not an exception to the rule. Is that understood?
Like I said,
Is that understood?
I don't understand how I'm not able to preserve my right to appeal.
You've already appealed this issue that you're trying to bring up. Yes, for today. And you are not going to further delay this hearing, ma'am. You already failed to appear for the exhibit conference. You don't have any exhibits to present to the court today at final trial after the mandate came from the Court of Appeals. There's no record. I have time. I have to be here. So we can sit here all day. It's up to you. When I call it, you don't get to tell me when I call the record, ma'am.
I'm sorry, I was in a hearing 2 years ago where you didn't call it to record and no attorney called it to record, and so it was not on record, even though there was a court reporter.
Okay, it calls to record when I say we're on the record, not when you say it. And I didn't call it to record.
She did not ask for a record.
She didn't ask for a record.
I'm asking for a record.
And you're fine to ask for a record, but we don't go on the record until I call the record. That's how it works.
And just from our standpoint, we'd agree. I think you've already issued a ruling on both of those motions.
I did.
I think she's entitled to get a ruling, which you've already given her. She's not entitled to have a hearing and then another hearing and then another hearing and then another hearing.
That is correct. That's not how this goes. When I call the record, we go on the record and we proceed with today. Until the Court of Appeals limits my instruction, I'm going to do exactly what I'm told. All right, Joy, you ready?
Okay.
All right, we're on the record in cause number DL23-11677. Counsel, will you please announce for the record?
Yes, Mr. Page, on behalf of Elliott Zimmer petition, and we're ready.
All right, and ma'am, would you please announce for the record?
Michelle Chase, pro se, respond.
Thank you. And prior to going on the record, this case was actually set to begin at 9 a.m. The court gave a courtesy to the parties to allow Ms. Chase to drive in. And there was an exhibit conference that took place at 8:30 this morning. The exhibit conference took place for an hour until 9:30 to give Ms. Chase an opportunity to appear. She failed to appear. Therefore, the respondent does not have any exhibits to tender to the court, and petitioner timely tendered exhibits. So at this time, petitioner's exhibits 1 through 83 will be admitted. Also, prior to going on the record, Ms. Chase attempted to make objections to the court proceeding with the hearing today, or even trying to preserve some sort of record with the court proceeding today. So the record is clear. The court has already denied her motion for continuance. The court has also denied her request to, for whatever reason, stop the hearing or delay the hearing so she has an opportunity to get a forensic accounting of any exhibits. The court is proceeding as pursuant to the mandate that came from the Court of Appeals to have a trial today only addressing the property division, which the court was reversed on and affirmed on everything else. Is that everyone's understanding?
Yes, Judge.
Can I make one clarification?
Is that everyone's understanding?
It's not my understanding.
Okay, so again, as I told you before going on the record, if you're going to entertain anything that the Court of Appeals addressed yesterday in denying your request for mandamus relief after this court denied your motion for continuance, your request is going to be denied at this point.
I respectfully request.
Okay.
notification. I did not receive notification. I was here at 9 a.m. Did not receive notification that the court would be delayed.
Okay, ma'am, I haven't sworn you in yet, but there is an entire email thread where you thank the court, actually. You thank the court for accommodating the parties, and council can verify that that is an email. So we are not going to do that today, ma'am.
Be not notified that the court would not.
Oh, it took place yesterday. You responded yesterday in the email.
And Judge Cards, if it's P82 and P83, that is the email thread you're referring to, so that's in the record.
It's a part of the record, ma'am. You responded. So at this time, council, you all have an hour per side. Ms. Chase, you also have an hour. Let me make sure that my clock is working today. It's been giving me problems.
Clarification, the date, the court is going to begin at 10 a.m. To give me a chance to get here, driving from Washington to have a pre-trial conference. I don't believe that it did.
I believe Judge Lee did say that she would have the conference this morning at 8:30 and do the trial, talk a bit for the trial, so.
I'm not, you all don't have to speak to each other. I'm not entertaining any further testimony about that because you can open your email and look at it yourself, ma'am. All right, so my clock is working. Attorney Page, Ms. Chase, you all have an hour per side that would include any opening and closing statements as well as any examination. Attorney Page, would you like to make an opening statement at this time? You may proceed.
Thank you, Judge. So, as you know, obviously you heard this case 2.5 years ago, for all the issues. Now we're back on property division. I want to be, obviously the Court of Appeals has remanded the entirety of the property division, but the sole issue that Ms. Chase had, that the Court of Appeals found issue with, was the performance units that Mr. Zimmer had through a prior employment. So, as we sit here today, with the exception of 2 assets, the parties have already divided up their estate. Now, obviously, with the remand of all their estates property, but it's down to the actual issue of, if we've got a 401k that is divided 55-45, we've already got quadros dividing that. The money has been spent on both sides. No, Ms. Chase is representing, she has no money, so she spent all the money from the divorce. Mr. Zimmer's paid off all his debt from the divorce. They had a Dallas house they sold off and split the proceeds of, and most of that money has likely been spent by now. So while we are here on a remand for the entire property division, our position is that there's also practical issues that we've already divided up most of the estate. So prior to coming to court last time, or the beginning of court, Ms. Chase's counsel and myself, or I should really say Ms. Chase and Mr. Zimmer, reached an agreement for an overall 55-45 division estate, which is an agreement you approved, and that I didn't see as part of the Court of Appeals, any part of the remand. So as we sit here today, my understanding is we still have an agreement for a 55-45 division of the estate. We've submitted a property division, which is attached to our Exhibit 1, and I've got a free-floating version later on as well. What we are asking for you to do today, by and large, is going to be exactly what you did last time. There's only going to be 2 changes what are the 3 changes we're asking you to do today. First off is what the Court of Appeals wants us to do today, which is take the performance units which Mr. Zimmer has and divide those in half. So 55% going to Ms. Chase, 45% going to Mr. Zimmer. The other thing is you ordered, at the time of the last trial, the parties had 2 pieces of real property. They had the Dallas house, which has long been sold. Mr. Zimmer was in charge of selling that property. Then you've got this Cloudcroft, New Mexico residence, which is where Ms. Chase still currently lives to this day. You had ordered that to be sold at the time of the last trial, and unfortunately, proceeding today, that still has not been sold. So Mr. Zimmer has not only filed a enforcement action in this court before, which you've clarified that this house needed to be listed at fair market value. He then had to file a case in New Mexico to ask a receiver to be appointed to sell this property because Ms. Chase just refuses to put this property for sale. She's living there, and she's not paying anything other than utilities and probably minimal property taxes. And as long as she sits there, Mr. Zimmer's 45% of those proceeds is just held up, and they're both spending more on attorney's fees just trying to sort that out. So we're not asking to divide the proceeds from that property differently, but what we are asking you to do today, Judge, is to order that Mr. Zimmer has complete control over the sale of that property, that Ms. Chase have to provide whatever consent is necessary for him to sell that, and that she vacate the property within the next 30 days. I think if you don't order those provisions on there, this house is never going to be sold, and they're going to spend more than the house is worth in attorney's fees. The last thing that we're asking for that you'll see is we're just asking for attorney's fees. We sent Ms. Chase, frankly, Mr. Zimmer has sent her a number of reasonable settlement offers throughout the multiple cases that we've had with Ms. Chase. We sent her a reasonable settlement offer just about a month ago saying that let's just keep the property division the same and then we'll give her 55% of these performance units. She didn't counter, she refused to accept it, she declined it. And so now he's had to spend attorney's fees for us to be back here today, including us just trying to fight this in the Court of Appeals yesterday and responding to that motion. So we're asking for attorney's fees there as well. So other than those changes, though, Judge, we're asking you to keep the ruling in place. That'll be in comporting with the 55-45 division, and that way I think your property division has fixed the issue the Court of Appeals have, and it also doesn't create practical issues for the two dividing and the remaining proceedings. So thank you, Judge.
Thank you. Ms. Chase, this is your opportunity for your opening statement.
Thank you, Judge. So what I'm asking for is, information regarding the Morgan Tool unit. Whether or not he's taken severance or a cash payout, and anything that could dilute the shares that I been ordered 55% of. In addition, the Dallas property was sold in less than 2 months of it being listed. We have both agreed that the value of the property was between 3.2 million and 3.7 million. He sold it in an all cash transaction for 2.7, 16% less than tax roll value. I would like emails between the realtor and anybody else to find out if there were deals that diluted the value from 3.5 average to 2.7 all cash. And I would also like wire and transfer information on where that money actually went. That's a lot lower than we had both agreed the value of the Dallas property was. In regards to the Cloudcroft property, I was not on the deed of the Cloudcroft property. You had ordered that I listed for sale August of 2024. I was not on the deed. It was a legal possibility. As soon as I was on the deed, I listed it immediately. It has been listed since. It is still listed by a broker dealer who has been a broker dealer realtor in Cloudcroft for probably 50 years at this point. Cloudcroft is a seasonal resort town. It takes a lot longer for properties to sell. I have kept up the property. I have been paying property taxes. I have done upgrades to the property. I've allowed showings. I keep my property immaculate. So if there is a showing when I'm out of town, anybody is able to go into the property that has been shown. People love the property. There are certain things that make the property difficult for some people. It has 4 sets of stairs. It is not my fault that the property has not sold. I have done my due diligence on trying to sell the property. As far as our estate is concerned, he took our entire savings account. He took all of our severance for 5 months and put it into a separate account or wire transferred it out of our account. There was almost $1 million missing out of our estate that I did not have time for a forensic audit because the last trial was expedited as well. That's why I'm asking for continued time to find out where this money had gone. In addition to that, I was only allowed in discovery to receive summary statements of our retirement accounts. I wasn't allowed full statements. It was ordered that summary statements are full statements. Well, unfortunately, that's not the case. Summary statements of retirement accounts only show you what money has been lost and what your account balance is. It doesn't show where the money that's been taken out or transferred went. I need that information. That is part of our community estate. I have a lot of missing funds.
I guess an objection,
sorry.
except this is now getting into a request for continuance that.
Sustain. In an opening statement, ma'am, you're telling me what the evidence is going to show and what your request is for today.
Okay, so they presented P82 in trial. And it's a summary of our monthly expenses. That was allowed in. We objected, it was overruled. There were no financial statements supporting this summary. And I know for a fact that line by line, this entire summary that was substitute under oath was a lie. For example, ESD over 6,000 a month, he said we were paying monthly. We paid ESD the year before out of community property. ESD tuition is due February of the year before your child attends. Line by line, I can go through and tell you that this was brought on the court and it was testified to under oath.
Okay, does that conclude your opening statement?
Other than I would like to preserve, I would like to preserve my previous.
We're off the record. I already told you we're not doing that. Does that conclude your opening statement? Thank you. We're back on the record. Is the realtor that you were referring to, is that the Loper person?
It is,
Okay, so that's someone new?
yes, so, when I originally listed the property with Debbie Lippert,
Spell her name, D-E-D.
DEBBIELOTER.
Thank you.
I had bumps. I had, everything prepared. She listed the property and then, he had my realtor.
That wasn't my question. I just need to know, was the realtor still Loper?
No, because she was interfered with. I would like to also make one more statement. He has,
Is this in your opening statement? Because if it's not an opening statement, you'll have an opportunity to tell me what you want me to know after his case in chief. I mean, if it's an opening, if not, he's going to object to it.
well, he has had me through the deed of trust, ensure that I've got residence for $500,000. And I listed it for $545,000. So it's fully insured at the request of petitioner for $500,000, full property. And I have that documentation here, and I have done everything requested to ensure that I'm complying with the deed of trust and everything that's been asked of me. And I completed it.
Thank you. Attorney Page, you may call your first witness. Okay.
And also, I think for Mr. Smug, we asked that the rule be invoked at this time.
Okay, and thank you for saying that. Would the two of you stand up and raise your right hands? Or mom too?
And on.
Yes, everyone. Do you all swear or affirm that the testimony you give will be the truth and the whole truth?
Yes.
Yes.
Thank you. So the rule has been invoked. So, sir, you may go ahead and have a seat because you're the first witness. Just pull the microphone to your mouth. Ma'am, the rule has been invoked, meaning that anyone who may testify as a witness has to sit in the hallway and wait until the bailiff comes and gets you for any testimony. You're not allowed to speak to anyone on this case, and you just have to wait in the hallway. I swore her in as a witness and he may call her, so he invoked the rule.
State the record.
I am with a lie, Charles Rice.
And can I give you, will we give you a? Quick swing, Judge.
Yes.
And you all exhibits. And I should return to tab number 68.
Yeah, it's on there.
And is this your CV?
Yes,
This summarizes all of your education, credentials, experience, all of that.
yes,
Okay, and you can designate the number of times the cases to testify as a financial expert in Washington, Texas.
many times.
Okay. Did I use you to turn to tab 69? And is this the engagement agreement that Mr. Zimmer signed, engaging your services in this case?
Yes.
All right. And as part of your employment in this case, what have we asked you to review and testify about today?
So I was asked to review and testify about the performance units that Mr. Zimmer had obtained in the course of his former employment with Oregon Tool.
Okay.
And basically the characterization of those and then commentary on the value of those.
Okay. And can you briefly explain how the performance shares work for?
Sure. So the performance units are, so Oregon Tool is owned by a private equity firm. And key employees like Mr. Zimmer gets performance units so they can share in the upside of the company, so to speak, only though upon the occurrence of certain events. So to some extent, they kind of are a cousin, so to speak, of say stock options, where a stock option is where a person, assuming the price of the underlying stock gets to a certain point, the stock option has value, the fair market value of the stock less the strike price. There's many, many variations of stock options and similar items, and this is one of them. The performance unit really is just something that could have value someday, but it really has no ascertainable fair market value until certain events occur. And in this case, the events would be a sale of the company or an IPO of the company or a cash distribution paid to equity holders. And those events are completely unknown as to the timing or the certainty or the probability. So these performance units, in this case, and I've encountered them many times before in other cases, they just don't have any ascertainable value at the point in time, because there's no information available that tells us when any of those events would occur.
And today's performance units today expire at some point?
Yes, these performance units will expire by their terms on December 31st of 2028.
And so as you testified, I just want to make sure that I've gotten it straight as well. So they have no value right now. They wouldn't have a value, if any, until we have some qualifying event like a sale or an IPO.
Now, those are outlined in section 7 of the governing document, the 3 events. Okay, that will tell us. So it's something we can't. I mean, with all the valuation tools we have, we just can't assign any value to it at this time.
And this is not a public company. We can't Google what the stock value is, right?
Right, but the stock value has no relevance anyway, because it's due, remember, IPO, so it's a private company, we get, so it has to be an IPO or the sale of the company or a cash distribution equity. Those are the 3 events.
To equity holders, is that what you're saying?
Yes, equity, yes.
And as we sit here today, none of that has happened. So Mr. Zimmer's not receiving any money for these shares right now. So,
It's my understanding none of those items, none of those events have happened.
okay. Is it your understanding Mr. Zimmer is no longer employed with Oregon Tool?
That's my understanding.
Okay, so the time of the last trial, Mr. Zimmer was employed with Oregon Tool, right?
That's my recollection.
And so if you turn to, can I just turn to tab 71 in front of you?
Yes,
And this is the OT Holding Corporation, which is OT Holding Corporation is Oregon Tool, right?
right.
And the 2021 participation plan, is this the plan that provides for these performance units?
Yes, it grants them, yes.
Okay, and then if we turn to, I'll have you look at 73 first. Was this one of the grant agreements that Mr. Zimmer got?
Yes, there were 2.
Okay, so this is, and you see the date of grant says November 2022.
November 7th, 2022.
And so if I call this one the 2022 grant agreement, will you understand this is the document referring to?
Yes.
Okay. And then if you turn to 74, same thing, we've got a grant agreement from July 29th, 2023.
Yes.
And if I call this the 2023 grant agreement, do you understand what I'm talking about?
Yes.
So under both of these grant agreements, was there a vesting schedule that you would receive and then have shares vested?
Yes.
Can you turn to exhibit 75 now?
Yes.
So since Mr. Zimmer is no longer employed, is your understanding that the vesting schedule is largely irrelevant at this point?
Yes, there's a set amount that he owns.
Okay, and in this letter, does Oregon Tool explain exactly how many shares Mr. Zimmer has as we sit here today?
Yes,
Okay. And they actually refer to the 2022 grant agreement and the 2023 grant agreement, right?
right.
Okay. So we sit here today, we know how many units he's got, but we've got no idea how much they're worth.
There's no way for anyone to know what the work.
Okay.
We don't know, and no one else knows, because there's no timetable, there's no projection, there's no forecast of when these events would occur. And we wouldn't know the magnitude of those events.
Or if they ever occur.
But yeah, we don't know, we have no information, so these, so as an aside, these items in IRS parlance have no ascertainable fair market value. And that way, when they're actually granted to people like Mr. Zimmer, there's no taxation at that point. So there's no value to them, so there can't be any taxation at that point.
And so, do you recall last time we were here, you still talked about how really the only way to tackle these is to divide it in kind, since we don't have a value for them?
Yes, that's how most stock options are divided anyway. I mean, even stock options are divided that way. They're typically not valued. These are absolutely the only way to do it is divide them and in kind, and then each person would get any benefits on an equal basis.
And so, as you sit here today, you agree that what we've got to do today is just divide these in kind.
That's yes, absolutely.
Okay, I'll pass it to Jim.
Thank you. Ms. Chase?
Hello.
So I'm unfamiliar with the way performance units technically work. I had read somewhere that at one point there was a value of like $1 per unit or something, but that could have just been an example that I
We
read.
have to decide our judge.
Sustained question.
Can you tell me if performance units can be negotiated out of or devalued by severance or cash payout before or if the event, the triggering event occurs?
It's highly unlikely. I guess as we say, anything is possible in the world, but these performance units and others like them are just governed by a strict agreement that typically cannot be deviated from. And whether somebody has the power to go in and make a unilateral change is almost unheard of. So I've never seen it in practice in 40 years as a CEO.
Would you agree that that would be something that I should be able to check into and be concerned about?
Well, I mean, as a qualitative matter, I think you would be entitled to discovery and information that's available in the normal course of business. But in terms of, I mean, these agreements are, the terms of these agreements are in the four corners of the documents. And there wouldn't be any way, in my opinion, or any reason for someone to need to go past that. It's just an agreement. Here, you get performance units. They may be worth something someday. They have a specific vesting schedule. They have an expiration date. And if it pans out, great. And that's pretty much it.
But would you agree that there could potentially be, at the time of separation of the company, an agreement that negates some of what has already been agreed on or alters some of what has already been agreed on in a new agreement and with the separation of the company?
Judge, I'm gonna object to calls for hypothetical.
Sustain.
Would you agree that there could be a severance agreement that could, I mean, would you agree that there are typically severance agreements?
Judge, I'm gonna object to calls for hypothetical. And calls for speculation.
Sustain as a speculation.
Are severance agreements typical?
Judge, I object to calls for speculation and also goes outside the scope of Mr. Rice's testimony.
Sustain as to outside the scope.
I have a question.
Anything further from Mr. Rice?
Real quick, Judge, Mr. Rice, have you seen any documents that would indicate that these shares have been devalued or negotiated around or anything like that?
No.
Okay, pass notes.
Okay. Is there anything further from Mr. Rice?
Yes. Have you been provided any other documentation besides what has been provided to you by opposing counsel?
No.
Thank you.
You're welcome.
Okay. Anything further?
No questions, Judge?
Is Mr. Rice free to be excused?
Yes.
Okay. Thank you for your time, Mr. Rice.
You're very welcome.
You're welcome. Counsel, you may call your next witness.
We call Mr. Zimmer.
Okay. Same thing, Mr. Zimmer, just pull the microphone to your mouth.
You state your name for the record.
Owen Zimmer?
And you were previously married to Miss Chase, right?
Yes.
Okay. We previously had a trial in this case, is that correct?
Yes.
And was Miss Chase happy with the court's ruling?
No.
And what did she end up doing? Because she was unhappy.
She appealed
Okay, and so why are we, as it relates to the appeal, why are we back here today?
to determine what they will be the performance units for individual.
And can I have you turn to exhibit 1 today? In addition to performance units, there were also, we're here on the other property division issues too, right?
Yes.
Okay, but the performance units was the issue the Court of Appeals had. Right. Okay. So the Court of Appeals didn't have an issue with how your 401k was divided?
No.
Didn't have an issue with the proceeds from the sale of either house being divided?
No.
Okay, so none of the other stuff was an issue.
No.
Mr. Page, slow down real quick.
I apologize,
I'm not, didn't have an issue with the proceeds of the sale.
From the sale of either residence. And I think I asked him if the Court of Appeals didn't have an issue with any other property division issues.
And I'd like to object to that.
Okay, what is your legal objection?
My legal objection is that the Court of Appeals remanded the entire property division.
And Judge, that's not what my question was. They did remand the property division, but they remanded it because.
You're saying specifically in the opinion?
Yes, correct. We are here today for the whole property division, but it's not as if they said the 401k was divided wrong or anything else. They just said the performance units had to be divided in kind, so we've got to divide. So
I'll sustain in terms of how the question was asked, rephrase.
when the Court of Appeals remanded the entire property division, in their opinion, the only thing they mentioned as error was the performance units. Is that correct?
Correct.
Okay. So I went to looking at exhibit 1.
I'm sorry, I'd like to object to that.
Okay, what's your legal objection?
My legal objection is that if they only found error with the performance units, they would not have redivided the entirety of the property.
Okay, so what is your legal objection?
My legal objection is that that's wrong. That's more hearsay. That's not what the Court of Appeals ruled.
Okay, overrule.
Thank you. So Billy, going through this exhibit 1, so we've got a spreadsheet attached here. This is what you're asking the court to do today, right?
Yes.
And then you're asking the court to order Ms. Chase to pay your attorney's fees in association with what you've had to pay for this remand, right?
Yes.
And on a cloud cost residence, are you asking, so it's a time of the last trial? Well, I mean, I'll go into this detail more, but you're asking for some changes on the cloud cost residence, correct?
Correct.
Okay. I want you to turn to exhibit 13 right now. And is this your inventory appraisement from the day before our last trial?
Yes.
Okay, so if we're looking at the value as the time you value the asset at the time you guys got divorced, this is our most up-to-date document, shows what those values was.
Yes.
Okay. And then I won't go through each one of these, but are you familiar with the exhibits P14 through P40?
Yes.
And those are each like statements or other supporting documents for each of the assets that are in the state.
Correct.
Okay. And if we looked at P47 through P56, are those supporting documents for each of the debts in the state?
Yes.
As far as your independent appraisement, if we're to go line by line on this and you're to talk about each asset in your community estate as of the date you got divorced, debt in the community estate as of the date you got divorced, would this document accurately summarize your testimony on that issue?
Absolutely.
Okay.
I'm sorry, which document were you referring to?
13. Can I get you to turn to page or to tab 63? Okay, and is this this court's rendition of ruling from your divorce?
Yes.
And it's dated March 20th of 2024, right?
Correct.
That was the date that the court divorced you.
Correct.
Can I get you to turn, I just want to go through some of these properties, so can I get you to turn to page 2?
Yes.
So if you look a little more than halfway down, you see there's the following confirmed to husband/father. So all the bank accounts sold in your name, those were awarded to you, right?
Yes,
Okay, and in the last 2.5 years, have you had both living expenses and attorney's fees to pay?
yes,
Did some of that money come out of the bank accounts?
yes,
Okay, and so the money that was actually awarded to you on March 20th, 2024, is that money still in these accounts?
no,
What about there's a promissory note to Harry Zimmer. So who's Harry Zimmer?
it's my father,
Okay, and you owed him about $131,000 at the time of trial.
yes,
Have you since paid off that promissory?
yes,
Okay, so is there any way for the court to redivide that and have this Chase pay a portion of it? If you've already paid the whole debt?
no, not practically.
Okay. What about, let's the 50% of the 2023 tax liability. Have you already paid that tax liability?
Yes,
Okay, and so there's no way to redivide that and pay it some other way because the money's already gone.
correct,
Okay, can I get you to turn to the next page now? You see there's the section that says real property,
yes,
and you see the first one is the marital home on Walnut Hill Lane in Dallas.
correct,
Okay, did the court order that to be sold?
yes,
And who was in charge of the sale?
I was,
Okay, and did you sell that property?
yes,
Did you, once it was sold, how were the proceeds divided between the chains?
55% to her, 45% to me.
And you guys have since divided up those proceeds.
Yes,
About when, if you recall, about when did that sell?
it was in the fall of 2021,
So almost 2 years ago.
correct,
Do those proceeds, as far as you're aware, just on your rate, the 45% proceeds, do all of those exist as we see today?
no,
So you've had to spend that money or some of that money.
I basically paid back my debts,
Okay. And you've heard Ms. Chase represented a number of times in this case that she has to, correct?
correct,
So that indicates that she's paid off she's spent all of the 55% she got from this house.
one way or another,
Do you recall the closing statement or the settlement statement you got when you sold this house
yes,
and how it divided up the proceeds between you two, right?
yes,
Was there a line item for money that was owed to Ms. Chase's prior attorneys that represent her at the last trial?
yes,
Okay. Is your understanding that, or your presumption that she's paid that debt off?
I'm not sure, I think there was. They got split 45 to me, 55 to her, and my understanding is that there was a lien and she had to work that out with the lawyers, and I'm assuming that I'll sort it out.
Okay. So just to be very clear and blunt, as far as the proceeds from the Walnut Hill Lane residence, do all of those proceeds even exist today for the court to redivide in some manner different from the way it divided 2 years ago?
No,
Just real briefly on the Cloudcroft residence, because I'll ask you about this later. It has, with that being posted, sold as well.
yes,
Has it been sold?
no,
How much of the proceeds were you entitled to?
45%,
So you have not received your 45% as it's been.
no,
Skimming through the cash and accounts for financial institutions. Have you and her divided up the accounts in a manner that Judge Bailey ordered in this?
yes,
Is all of that money on your end at least still in those accounts? No. So is there any way to redivide those to different hands today?
No.
I want to turn to the next page. Same thing with the brokerage accounts. Have you guys divided up those accounts that way?
yes,
Do all of those funds exist as we see? Not that. Okay, the Oregon tool bonus, did you guys divide up that?
yes,
And do all of those funds exist today? No. What about the retirement benefits for the 401k? Is there a quadro the court signed to divide up that 401k?
yes.
And so you've got your part, she's got her part.
All the retirement accounts now, it's split 55 to her, 45 to me with that quadro.
And they were split, you weren't taxed for the distribution because it was a transfer instead of divorce.
Correct.
Okay. Would you have concerns with the practical nature of trying to bring those accounts back without tax consequences and be divided in that way?
Yes,
With the stock options, so we'll talk about performance units in a little bit. You are asking the court to divide those up differently today, right?
correct,
Okay, and that's in line with what the Court of Appeals said.
yes.
Okay. Club membership and travel were benefits. Have you guys already?
And travel what? Slow down, Mr. Page.
Sorry about that.
That's okay. Club membership
Club
and travel what?
memberships and travel award benefits. Have you and Ms. Chase divided up these accounts in a manner that they're ordered divided here?
Yes,
Do all of your airline miles and travel benefits that are listed here, they still exist as of today. And just for the record, if you just wait for me to finish the question before you answer the question. So the motor vehicles down at the bottom of the page. There's a 2018 GMC Yukon. Does that car still exist today?
No,
Have you sold that off?
yes,
Is there any way to now award that to Ms. Chase?
no,
If you turn to this next page. There's credit cards and charge accounts, and there's 5 different credit cards listed. You see that?
yes,
And they're all already paid by you, correct?
yes,
Did you pay all of those?
yes.
So those debts don't exist. Correct. Okay. So just to, and I'm sure that, you know, we're going overboard on this, but you're asking the court from a practical standpoint, not to redefine other assets because we've got divisions already, that's right? Correct. There's,
Yes,
are there, what are some concerns? So if the court were to redivide the assets, like let's say it takes an account that's reported to you and splits it up 55/40. Takes an account where it's Chase and splits it up a different way to them. What would be some concerns you would have from a practical standpoint?
yeah, I got 3 concerns. You know, practically speaking, going back 2.5 years, trying to revalue everything. With different, you know, parties and all those kinds of things, practically speaking, it's impossible. Secondly, it would be excessive. So people that would try to do it, try to bring in accountants, lawyers, third parties to try to put all that back together, and people that can understand all that stuff. So it'd be extremely expensive. And then third, we're 2.5 years in now, and we still haven't divided the estate. And so then trying to redivide after getting all the accountants and lawyers, I can only imagine how many times we'd be back in court trying to figure out what to do with each and all of these different items.
Yeah, so talking about that last point, just the money that you have to spend to get these things, like, what's the relationship between Chase and like?
We don't talk.
Are you able to productively discuss anything?
No,
We talked about the firearm residence. Obviously, that's not sold 2.5 years later. What have you done? I'll start just in Texas. What have you had to do actually to try to get that sold?
yeah, I've had to come back to this court with a motion to enforce.
And did you have to pay all law firm attorney's fees to have that happen?
Yes,
And the court ordered some attorney's fees against Ms. Chase then, correct? Did she ever end those? No. In fact, she appealed that as well, right? Correct. Did you have to pay us attorney's fees to defend that?
yes.
What did you have to do then in Mexico to try to get this New Mexico listed?
The divorce decree said that we were allowed to appoint a receiver. So then in New Mexico, I had to go hire another attorney to then go down the process of appointing a receiver, and ran into the same issue. So at this point, I spent tens of thousands of dollars trying to just get a receiver appointed, to which that hasn't really worked itself out. For good reasons.
So if, let's say the court takes one of the assets that was awarded to you or to Ms. Chase, redivides that. Do you think that Ms. Chase would cooperate with you and redivide that easily?
No,
Do you anticipate we'd have to get at least some funds involved to get that divided?
yes,
But that's an extension you don't want to extend, correct? You've been, this is not the only lawsuit you had with the Chase, right? Correct. You testified about the New Mexico lawsuit. You testified just now about the enforcement lawsuit in this court. She filed 2 appeals out of this case.
yes,
That she filed recommending the citizen of this case.
yes,
And for each one of those, she had to have us represent. Yes. And then there's also a modification case with the opinion right now.
right,
And she had just asked for a jury trial and it's early this year.
yes.
Has she seen your daughter, who's still a minor child? Has she seen her in the last year?
No,
Does she still wants a jury trial on that issue?
yes,
So are you ready to be done with all the litigation in this case?
that just like to move on.
I want to go here to you turn to 64. And this is the, well, then let me turn to 66, actually. Are these the findings of fact and conclusions of law that this court signed after the last trial?
Yes,
Can I get you to turn, so there's an exhibit A attached to the back. Can I get you to turn to page 2 of that?
yes,
And you see how, the court has every single asset from the estate listed with a value?
yes,
And so those are the values, as you understand, that's the value for each of these assets that the court found out of evidence interest.
yes,
Okay. And then if we go to the next page, or we starting at the next page, we see the same thing with the debts, where Judge Bailey looked at the evidence and found a value for each of the debts. Correct. I want you to turn now to exhibit 67. So this is your proposed property division,
yes,
and this is identical to what's attached to your exhibit 1.
yes.
Okay, I want to go through this real quick.
With some, it's identical with some exceptions.
Yeah, well, it's identical to the one on exhibit 1, though, right?
Yes,
Okay.
same spreadsheet.
So, and then with the exceptions, most of these values are the same values that Judge Bailey found for the original trial, right?
Yes,
Most of them would also then be supported by your exhibit. She already admitted into evidence that support the values for assets.
yes,
Okay, I want to talk about the exceptions, let me finish. So you see line 1 under real property or list of Walnut Hill residence
yes,
is the value listed is 895,000 and it's a change. Is that different than what the court found from this last trial?
yes.
Why is this different?
It is the net proceeds after the sale and after we paid off the mortgage. So what you'll see in the spreadsheet is there's no longer a mortgage in the debt section. But after the sale, because the mortgage was paid, so it's the actual net proceeds from the sale of the loan.
Okay, because at the time of trial last time, this house had not sold, right?
Correct.
And now that we're 2.5 years later, we know what the value is because you have sold.
Correct.
So this reflects the actual amount going.
Yes,
Okay, I want to go down to line 13 under stock options. You've got the OT Holding Corporation performance units.
yes,
Are those the performance units that would be issued or get here?
yes,
Okay, and last time the court awarded 100% of the team, correct?
correct.
How are you asking that they be divided today?
55% to Ms. Chase, 45% to myself.
And that is in line with the agreement everyone reached before trial last time for 45-55 additions.
Yes,
It also says total of 4,506,840 units.
yes,
At the time of the last trial, were you employed by Oregon?
yes,
Was there a whole vesting schedule for how many units you had would get to invest over time?
yes,
Okay. And as we sit here today, are you still employed with Oregon?
no,
When you left Oregon Tool, did they confirm the number of shares that you told them?
yes, based on that vesting schedule, based on the time that I left Oregon Tool, it was calculated, and that's 4,506,840 is the amount of units that I vested that I've then left Oregon Tool with.
Okay, so if we look back to even information available at the time of the last trial, we could calculate the vesting schedule, right?
Yes, and in the exhibits.
And when did you leave your employment with Oregon Tool?
In basically May of 2025.
Okay, and so in May of 2025, this is the number of units that already vested.
Correct.
Okay, and so they said they let you walk away with the vested units and you didn't get any units that were not vested.
Correct.
Okay. Are there, well, I know I'll move over here. Going down to, let me have you turn to the next page. You see at the very bottom of the liability section, item number 10 is the 2023 tax liability.
Yes,
You have $41,805 listed. Is that how much was listed at the time of trial?
yes.
What was listed at the time of trial then?
I don't think so because it was right before tax season.
So, had you paid taxes in March of 2024 for the 2023 season?
No,
So did we have an estimate for what you thought taxes were?
right,
Okay, since then, you now paid those taxes.
yes,
So now, where do we get this $41,805?
that's the actual amount that's paid.
Okay, so other than the amount of the taxes, the net value, the net proceeds from the Wallen Hill residence and the division of the actual units from the performance units, the rest of this is all the same based on what the court found last time.
Yes,
Okay, and real quick too, going to the Cloudcroft residence, 'cause I want to talk to you a little bit about that next. You got a value listed at about $397,000.
yes,
Have you, even throughout the lawsuit in this case, we worked with at least one realtor who works out in Cloud.
right.
And based on comps and what she's testified to, do you believe that $397,000 is an accurate figure for what that property was worth at the time of the divorce?
Yes,
Okay, so you still stand by this 397 figure?
yes,
So let's talk more about the cloud conference. I think we probably hit most of the points already, but do you recall, so the court ordered that house to be sold, right? Right. And the court put a deadline for that house to be sold.
yes.
Was there an issue where Ms. Chase had sent you like the listing agreement the day before, the evening before it was supposed to be listed?
Something like that.
Was it just a listing agreement or were there like asterisks that she had told the realtor to put?
Or was there asterisks?
Asterisks, yes. That she told the realtor.
Yeah, if I remember correctly, the realtor wanted me to sign something basically waiving my ownership stake or something. As was viewed,
And did it get listed, because that did it get listed by the deadline? Correct. Correctly, not listed by the deadline.
it was not,
When it finally was listed, was there an issue with the way that it was listed?
yes.
What was the issue with how it was changed?
She listed it with a price that was way above the 397.
Do you recall, was it about just under 600,000?
Yes, over 500,000.
Okay, which was not at all in line with what the evidence showed. Right. As far as you're aware, have there been any prospective buyers for the property in the last 2.5 years?
As far as I'm aware, correct.
Did it get taken down from being listed at some point?
For a while,
Okay.
yes,
And so today, one thing you're asking, so in the last ruling, Ms. Chase was given control of the South New Mexico residence, and you were given control of this Elford Dallas residence.
yeah, and she was told by this court to list it at a price where you get willing buyers and willing sellers to come together. So basically told to take the price down to a place where the market would.
Objection. That's not what we said.
Okay, what was the legal objection?
Objection, that's not, it's false information.
Judge, I think you can cross-examine. That's the case.
Yes, overrule.
So with you being in charge of the Dallas house, that's the only house that has sold. Right?
Yes,
You heard Ms. Chase even just today say that something went, she made some sort of allegation that there was some underhanded stuff in the sale, and you sold it for way less than it was worth. Right. Okay. Do you believe you sold it for less than it was worth?
no,
Okay. Did you work with the realtor to get it sold?
yes,
And did the realtor did he think that was good price to sell it?
yes,
So you're asking the court to give you now that we're coming back and doing this the second time, one of the changes is you want to have control over the sale of the Mexico residence, right?
yes,
Do you think that's the only way we're gonna get this thing sold?
yes,
Or as part of that, are you asking that Ms. Chase be able to vacate that residence?
yes,
So is she living there right now?
yes,
There's no mortgage on it, is there?
no,
So other than utilities, and property taxes, she doesn't have the expenses for the property?
correct,
Okay. Do you think that she's motivated to sell the property?
no,
Do you think she has motivation not to sell the property?
yes,
And that's clearly evident by the fact that we're 2.5 years later, we haven't even got offers on the property. Correct. Okay. But you're still asking the court that once you sell it, split it up 55-45 like the old estate. Correct. Okay. Before I go to the performance units, I want to turn your attention just real quick back to exhibit 67 in front of you. Can you turn to the second page?
Yes,
So you see down at the bottom, you add all these values in, it's got about 43% to you and 57% to this chance, right?
right,
Okay. So you guys agreed to a 55-45 split.
right,
And technically, this is actually a little more favorable to this chance.
yes.
Okay. Are you asking, or are you fine with it being a 57-43 if we can just get it done today?
Yes,
Okay. Like you said earlier, if I need to have this be done.
yes,
Okay, so you're making no objection to 57-43.
right.
Okay. Let's talk about performance units. Well, I guess I've asked you some question about those. On the Clowncoff residence, you understand Ms. Chase was trying to argue in the last time that that was a gift to her.
Yes,
Did you gift the Clowncoff residence to Ms. Chase?
no,
There was, so the deed went from being in your name to both of y'all's name, correct?
correct.
Can you explain for the board why that's the case?
Yeah, when we were setting a title for the closing, we noticed that they basically almost put my name on the title, and that's because I did all the work to get the closing. I sent all the documentation or whatever. While we were there, Michelle and I realized that, and we realized that we should get the paperwork cleaned up. We asked the title company the best way to do that. They couldn't reverse all the closing procedures, and so then we had that paperwork done after the fact.
And so it was just, your both of y'all's name being on there was the gift. Are you saying that it was just to reflect that that was community property owned by yours? And the court, they found that to be community property last time, right?
Yes,
And the Court of Appeals didn't take issue with that.
correct.
So I wanted to talk real quick about settlement offer as well. Can you turn to exhibit P80? Do you recognize this document?
Yes,
Is this the settlement offer that we sent to this Chase?
yes.
Just big picture, can you tell both Bailey, what did you offer this Chase on June 30th of this year?
Yeah, I mean, verbally, we offered this right away. The same, just one move on, 55-45. And so big picture, what's offered, the settlement offer is 55-45 split of the Oregon total performance units. We also provided the evidence of how many performance units were there. We reached back out to Oregon Tool so they could provide all that information. And then secondly, I offered a path for Ms. Chase to stay in the Cloudcroft residence by buying out my 45% for a reduced price of $75,000. This is something that the Mexico attorneys had actually already talked about. We brokered over email, a settlement, if you will, over the Cloudcroft residence. So I thought we would package the two together, try to get the two issues behind us.
Did Ms. Chase accept that offer?
No,
Did she even send you a counter offer?
no,
Have you had to spend money for attorney's fees since then?
yes,
And are you asking the court as part of your request today that Ms. Chase be required to pay you with reimbursement for all the attorney's fees you've incurred since the settlement?
yes.
Who all pass the witness?
Okay. Ms. Chase, you may cross-examine.
May I have him sworn in under the Bible?
He's been sworn in.
I.
You may proceed with your questions.
I want you to know that you were under oath. And that you were swearing.
Objection, silence.
You got,
Sustained. Just ask your question, ma'am.
don't lie. Can I present this? This is an exhibit.
You can approach him and ask a question.
This is your exhibit that you testified to March 7th of 2024 property division. Do you understand that lying under oath in division of property or modification of child custody is a felony.
Judge, I don't check this compound question. Also, this is an exhibit. I haven't seen it, but it sounds like not one we have today.
Sustain. And Ms. Chase, again, I'll remind you, you have to ask him a question.
And I don't
Yeah.
Without the sidebar, you have to ask him a question.
stand that testifying under oath in division of property or modification of child custody is a felony offense.
Objection calls for legal conclusion.
Sustain, and the questions can only be limited to property division.
Okay, and that is fine. He brought up a lot of different things. Have I seen my child in a year? So, I mean, this goes to a lot.
You can ask your question.
Do you see anything in this document that isn't true?
I'm gonna object to her asking him to testify to not an evidence.
Sustain.
School tuition, this is a monthly fee, monthly schedule. School tuition, did we pay $6,250 a month for school tuition at the Episcopal School of Dallas?
Judge, I'm gonna again object to her asking.
No,
the question.
or did we pay for it the year before?
Sustain.
To not,
Sustain.
Did we pay monthly?
Ma'am, you have to ask your next question. I've already sustained that objection.
I document, I'm asking him an actual question.
About the tuition, right?
Did we pay tuition?
Right, and I'm telling you, you have to ask him another question. You cannot ask him that. I've already sustained the objection.
Pay for Christie in 2022 and 20.
We had two daughters going to ESD, and if I remember correctly, ESD is roughly $35,000 to $40,000 a year per. And so times two, that's $70,000 to $80,000. At different years, while they were going up, in different years. We were fortunate enough to either have a bonus or somebody had to come and set aside savings so that we could pay everything up front.
And so we did not pay it monthly, correct?
We divide $80,000 by
We
12.
paid it with community property the year before.
I don't understand the question.
We did not have a monthly fee in 2023 or 2024 for school tuition. We have paid it in full in February of the year before. Correct?
Go ahead.
I offered.
Wait a minute, hold on, sir. I didn't get Mr. Page's
I
objection.
think she hadn't corrected. I'm saying objection sidebar, but she hadn't corrected yet.
Okay. You may answer the question, sir.
I offered them. And we paid for a community property for an accountant that you chose. To go through each and every one of our, all of our different finances and all different steps. Michelle, I'm answering the question. Michelle, when there's a difference between cash flow, net income, and how money actually flows. And so in that schedule, when I take $80,000 and divide it by 12, take $80,000 divided by 12, is how much, Michelle?
You're not asking.
It's roughly
I'm
6,000.
asking you questions.
I'm answering your question. So it's 60.
To the court as to where our monthly fees were going. Is that true?
Judge, I object that she hasn't even finished his answer to the question.
Sustained, and I guess, wait a minute, Ms. Chase, what is the relevance to this line of questioning to the property
I'm
division?
sorry.
No, I'm sorry, because you're not gonna cut me off anymore. What is the relevance of this line of questioning to the property division?
We were missing $500,000 in savings, $65,000 a month in income, part of which was community property severance for 5 months. He presented this document and presented an line item of every single penny as to where that $55,000 a month we were spending. This was a complete lie. I have documentation as to it. And I'm just trying to get him to answer. Did we spend $6,200 a month in school tuition, or had we paid it out of community property the year before the divorce was even filed?
And I asked the question again, what is the relevance to today?
And spent. This is community property that the Fifth Court of Appeals has remanded And I'm trying to tell everybody that this is not where our money went. Where did our money go? And it is findable, but this is a lie. This is not where it went.
Okay,
It says, did we spend $200?
so you didn't present any exhibits to show otherwise? Okay, so you can ask him another question. I just want to remind you though, every question that goes outside the scope of what the Court of Appeals tasked me to do, he's going to object.
Okay, so the entire property was remanded.
Oh, you're asking him a question.
So I'm asking you, the entire property was remanded. In school tuition, were school lunches included in that school tuition?
Object to compound of this question, if it got demanded, or if it's a question of tuition or school lunches.
This is that's where our community property has gone.
Sustain, rephrase.
Okay. Did we pay $200 a month in school lunches?
I guess subject to the point of relevance. I also don't have any, if there's a.
Sustain to relevance.
Yeah, if there's different ways claiming from what she brought last time, we had no notice.
I'm sorry, I am representing myself per se, so you'll have to forgive me if I'm not phrasing questions properly. I'm not trained in litigation. This is the first time I've ever been in front of a court. So I'm trying to get at where our community property has gone. He has stated it's impossible now to evaluate our community property. And it's not.
Well, again, this is your opportunity to ask him any questions that he has. And if you believe that he's not being truthful, then you were able to present any documentation to show otherwise. I don't have that before me. So the appropriate what you're trying to do, I think it would be better if you wait until it's your case in chief and tell me what you want to know, because the line of questioning you're trying to get out of him, you're not going to be able to overcome the objections that his attorney is making.
Okay, so can you clarify? I'm sorry. So when it's my case in chief,
You can tell me what you want me to know.
okay, so when he's questioning me, is that what you're saying?
No, you'll go first and tell me what you want to know, and then he will cross-examine you on what you said.
Okay.
Yeah.
Thank you.
You're welcome.
Okay, so, the entire property is being redivided. Can you tell me, what happened to our children's bank accounts?
Object to vague on which accounts we're talking about.
It's the
Savings
same.
accounts. So my children had 2 savings accounts. And I want to know what money was taken out of the children's savings.
The objection was sustained, so.
It was sustained. So you may ask your next question, ma'am.
Okay. Did you take me off of all credit cards against standing orders?
Object to relevance. This is not enforcement action.
Well,
Sustained.
not liability for the credit.
Sustained. You may ask your next question.
All right. Please see exhibit 15. We have 15. 15, it's, oh yeah, it's all 15. Would you like to see my notebook?
No.
Can you please read the address?
But I will know.
5115 Walnut Hill.
Yeah.
Can Can you please read the estimate value of the property?
$3,524,500.
Can you please read the date that this was printed on?
It's February 29th, 2024.
Correct. When was our home on Walnut Hill sold?
September, October.
When was the contract on the home signed?
2004.
It was signed in August of 2024.
Object to the sidebar.
Sustain.
When did you list the property for sale?
In the summer,
Do you have the date?
sometime in June.
How long was the property listed before it sold?
I listed the property after I left in town,
How many months before it went under contract?
a couple of months.
So do you think that it's fair that the property estimate was over 3.5 million, but yet you sold it for all cash for 2.7? And I have no information as to whether or not negotiations were made. Were negotiations made with the seller? Was there more benefit to you besides that 2.7 million?
What questions do you ask?
I'm asking you if there was more benefit to you in the sale of that property in addition to the 2.7 million cash.
That's ridiculous, so,
Oh, really?
yes.
You are under oath.
Yeah.
Okay. You believe that the property estimate being 3.524 and selling it 2 months after it's listed for 2.7 is fair market value?
Yes.
I would like to see proof of that.
Object to the sidebar.
Sustain.
Did you, in addition to your annual Oregon Tool bonus, receive a Christmas bonus?
Objection vague as to which Christmas we're talking about.
2024,
Then I'd object.
2023 Christmas bonus from Oregon Tool.
No,
Yes, you did.
Objection sidebar.
Sustain. You only can ask him
Did you
questions,
split
ma'am.
that Christmas bonus 55-45.
I don't know what a Christmas bonus is.
He's already testified there was no Christmas bonus.
Sustain.
This isn't the 1950s when we're handing out Christmas bonuses.
You got a Christmas bonus from Lennox every year, and yes, you did. I got the receipt of the Christmas bonus.
Object to the sidebar.
I
Sustain.
have information being turned over. How many times have you sued me?
Object for relevance.
No, it's where our money
Sustain.
has gone.
Sustain. You may ask your next question.
I'm trying to figure out where our finances have gone.
And I'm trying to figure out why you're not asking the next question, ma'am. Go ahead.
How much have you spent in legal fees suing?
Objection relevance.
Sustain.
How much more did you spend in trial than I did out of our community property? And I was not allowed equalization of attorney's fees,
Objection vague.
$100,000.
Objection vague and compound.
I had.
Sustain.
attorney's fees.
One question at a time, ma'am.
I can't even seem to get a question through. I'm trying to figure out where our community property has gone. This is the remand of the entirety of the property.
And that does not mean that you're not free from getting objected to. Sustain.
Did I receive equalization and attorney's fees?
Objection relevance.
Sustain.
Community property. How much did you spend in attorney's fees in trial?
What trial? Well, we're on our third one and.
This is our second trial. This is the remand of property division. Our first trial on March 7th was 2024. How much did you spend in attorney's fees?
Judge, I object to that being vague, to the extent that he would know exactly what was going on.
Did you-
Motion. Mr. Chase, can I finish my objections? to the extent you would know what is for a trial preparation versus coordination for some other event. Also, for what it's worth, we've had a trial in multiple different cases like the enforcement case.
Then you sign-
Sustained. You may ask your next question.
Okay, so. Did you take all of your attorney's fees out of our savings and out of our severance?
Check the relevance.
Sustained.
Community property. That is,
There's a balance sheet that was presented earlier, and that's the balance of what the community property was.
because you took it out, you.
Okay, question.
Question, did you set up? Did you go against standing orders?
Objection relevance because we don't have enforcement set here today.
Sustained.
Standing orders clearly state you are not to set up a separate account nor take money out of community accounts. Did you do that?
Objective compound and sidebar at the beginning.
Sustained.
How many credit cards did you take me off of?
Subjection vague as time frame.
Okay,
Sustained.
was it 5 credit cards? Did you take me off of 2 credit cards, 3 credit cards, 4 credit cards? How many credit cards did you take me off of and then run up credit card debt and use it as your liability
Objection.
against me?
In vague time frame and compound.
Sustained.
I want to get back to the cloud property. I was not on the deed of the cloud property, correct?
I think that everything around the Cloudcroft property was turned in at the time of the court. It's all in all the exhibits and it's everywhere, so.
When was the deed of the cloud property signed over to me?
But I guess object to vague because I think there's at least 2 deeds to that property and evidence right now. I don't know if she's referring to the sale later on where she got a deed from the divorce.
Sustained. Rephrase.
Was I legally able to put the cloud property on the market by August 1st?
Object calls for you.
Did I?
Hold on 1 second. Let me read back your question. Was I legally able to put Cloudcroft property on the market by August 1st? Sustained. Rephrase.
Had you signed the deed over to me for the cloud property by August 1st of 2024?
It was your property, so.
Do you understand it's a legal impossibility if one is not on a deed to put a property up for sale?
I guess I'm object, when I'm as a legal conclusion, but it's the whole line of questioning that if we're talking about the sale of the property that was ordered to the divorce decree that Ms. Chase herself is had overturned, it's not a relevant question for dividing a community property as of the date of divorce.
Sustained.
Did I ask you to sign an addendum that would have allowed me to have listed the cloud property on August 1st of 2024 so I could comply with court orders?
And again, I object.
He asked him about it. He asked him about it.
To sign an addendum that would have allowed me to have listed the crowd.
But I'll actually withdraw my objection. If she wants to spend her time going down this route, that's fine by me.
Thank you.
Okay.
Did you sign the addendum?
Just give it a second. I think it was the day before August 1st, I got an email from the realtor Debbie Loper.
Is it a yes or no question?
I'm sorry.
Did you sign the addendum?
Should I hear if there's any objection to that? So I can be able to finish his
I
answer.
think
Hold on 1 second. My court reporter cannot write down what everyone is saying.
Same time. You only get one person.
So I was gonna say, if there's not an objection, I'd like Mr. Zimmer to be able to finish his answer.
Okay, so was the last question, did you sign the addendum?
Yes.
Okay, Mr. Zimmer, answer that question.
Yeah, I don't know. I don't know what you're talking about, so what I'm trying to do is explain from my side what I saw. And
Objection narrative. Your attorney asked you to.
Hold on. You asked, what do you want him to say? Did you sign the addendum, sir?
ultimately, I signed an addendum that allowed her to sell the club.
No, you did not.
Okay,
Yes.
so he answered that question. Go to the next question.
Not, then I was not able to list the property on August 1st of 2024 because the deed was not signed over to me until September. The day the deed was signed over, did I list the property?
Sustain.
Did I list the property?
Sustain. Ma'am, you have to ask a question.
Did I list the property as soon as the deed was signed over to me?
Yeah.
Are you lying under oath again? You understand you're perjuring yourself.
Objection is carried. We had to hold enforcement because she waited like a month and a half after getting that addendum to list the property for sale.
And we will go to that. So I wrote an addendum. I could have listed the property by August 1st, 2024. You would not sign
Okay, sustain, hold on.
addendum.
The court of appeals told me to do a job. They told me to remand the property division. The line of questioning that you're asking of him is not helping me make the decision that I need in terms of what you would want me to do. Are you wanting me to find out whether or not he's telling the truth about the addendum? That does not matter to me. What matters to me is what the Court of Appeals told me to do. And if you keep asking him the same question over and over again, all you're doing is diluting what I need to do, and you're not helping your case.
Trying to defend against what he asked his client, which
Okay,
is not the full truth.
but here's the deal though. You're going down a rabbit hole trying to play defense that's not helping you. All you're doing is running your time out. He has 21 minutes and 3 seconds left. I've taken so many notes on the questions he's asked his client specifically about the performance shares and cloud crawl. That goes to the property division. You have 29 minutes and 17 seconds left. Only thing I know for a fact is that you believe Mr. Zimmer is not telling the truth and that he did sign the property addendum. Or had you signed the property addendum? That's all I know so far from him.
Yeah, my first time in court, when he questions his client and misleads the factual information, I am trying to legally figure out how I can rebut the misrepresentation of exactly what has happened.
Usually when you're trying to rebut based on the questions that you're asking him, you will provide some sort of document or some sort of demonstrative aid to assist the court. You didn't provide that.
I've had 14 days.
Okay, we're past that.
Okay.
We're in the trial.
So I'm doing the best I can in 14 days, representing myself when an attorney is misrepresenting.
Are you going to ask him a question?
I'm going to try, but everything keeps getting objected and sustained. So.
And that's what happens in court, ma'am.
Obviously, especially when I'm the respondent.
I just like to, Ms. Chase is a licensed attorney. It's not like she doesn't know what's going on. She went to law school. She knows what hearsay is. She knows the rules of evidence.
The court is aware.
15 years.
Okay, you may ask your question.
Nice try, Spencer. And yes, I passed through bar exam and I have an LLM, but I spent.
Miss Chase, congratulations on all of your accomplishments. I need you to ask him the question.
What happened to the 500,000 in savings?
But I guess objective vague is what we're talking about.
Sustain.
Our lifetime savings after a 24-year marriage, we had 500,000 that went missing and it went into a different account against standing orders.
Object to that in sidebar.
Why would you have $100,000 more in attorney's fees in 6 months than I would?
I don't know, Michelle, on that one.
And why did you take that out of community property? So I had to take out loans to pay my attorney's fees.
I don't. It's the extent that it's anything we've talked about, I'd object to attorney-client privilege.
You mentioned earlier,
Hold on 1 second. Why would you have $100,000 more in attorney's fees in 6 months than I would sustain?
You wrote in your line items, and you just mentioned it as well, that we had club fees and expenses. When did we drop our Northwood Country Club membership? Was it on or around August of 2023?
I'm just trying to think back.
Yeah,
Hold on 1 second. What's the objection? I don't have it.
Yeah, I'd like to object that he's not finished his answer to the question. I'd like him to be able to answer the question before Ms. Chase has to say.
I'm sorry.
Okay, you asked him, when did you drop our Northwood Country Club membership? Mr. Zimmer answered that question.
I think it was in the fall of 2023. We were hemorrhaging.
It was August of 2023 when you filed for divorce.
Object to the side.
Sustained, ma'am, when you ask him a question and he answers it, you cannot get combative. Okay, that's it's, you have to ask him a question and keep asking him questions. You cannot interject your commentary.
So you've included that in your line item of expenses as well, when we actually didn't even have a country club membership.
Yeah, object, that's again asking to testify to
Did we?
not in evidence.
So you have included that.
Wait.
So you have included that when we actually didn't have a country club. Okay, finish that question.
Did you testify under oath that we had country club expenses when you had actually canceled our country club membership 6 months before trial?
Is there any? I should be looking at it. I don't know. You're bringing up stuff from 3 years ago that isn't even in the book that we've been talking. And question me on something that you got a piece of paper of, and I'm not really understanding why.
Did you take our community property
I tried
and
that.
take your girlfriend to Paris on our community property?
Object content.
Sustain.
Did you use our community property to buy your girlfriend furniture?
No, I didn't.
Did you use our community property to travel with your girlfriend?
I'm not sure because she has a job, so she pays for all her stuff and I pay for mine, but.
Did you use our community property to spend over $1,800 on Coldplay tickets?
Object to, I guess, I really don't, the best evidence. Well, there's evidence of some $1,800 tickets. I'd like to see it.
Okay, well, you
Sustain.
want to see it? Waste of community assets on Paramore, $40,566.94.
Sorry, is this, are you looking at?
Additional, this is my exhibit from the first trial.
Did I, there's an objection to asking
You
questions based on.
you said you wanted.
Wait, but one at a time, please. One at a time.
I would object that she is asking the client, the witness to testify to not done.
Sustain.
I could not present evidence.
Sustain. You may ask your next question.
Well, it's pretty clear that,
We're off the record.
he has stolen all of our community property and I have.
Does that conclude your cross-examination?
See what else.
Mm-mm.
Did you charge up credit card debt?
Now we're back on the record.
Did you charge up credit card debt on credit cards that I had no access to and claim it as community liability?
Object content.
Okay, I'll ask them separately. Did you take me off of credit cards?
Today is the time frame.
Sustain which time frame?
Did you take me off of credit cards starting in December of 2023?
Sure, so you know the stuff around, sure.
Do you know that that was against standing orders?
Object calls for legal conclusion and relevance to their.
Danny,
Sustain as to relevance.
It's community
I
property.
remember responding to every discovery request that was sent to me. I remember going through 2 rounds of mediation. I remember
That's not
being
what you-
in every deposition. And that's probably why my legal fees were
That's
sized.
not what I asked.
One at a time. Let him finish.
The last thing he said was that's probably why my legal fees were as high as they were.
So I think for.
Hold on 1 second, sir. Now she needs to ask the next question.
Did you take me off of credit cards?
I'm gonna get to ask the answer because he did answer that question.
Sustain.
I didn't hear the answer. I'm sorry, forgive me.
No, don't answer that question, sir. I sustained it. You may ask the next question.
Did you rack up credit card debt on credit cards I did not have access to?
Object to relevance on, he's allowed to use credit cards that he doesn't have access to.
And she's paying it as community liability.
That's how community property works.
1 second. Did you rack up credit card debt on credit cards that I did not have access to?
I was on.
Hold on 1 second. Sir, answer that question. Did you rack up credit card debt on credit cards that she did not have access to? It's yes or no.
I don't know how you define rack up, and B, I really don't, I can't recall from 3 years ago how we were cash flowing our life. I know that we were hemorrhaging because we had a very expensive property that we couldn't afford. We were hemorrhaging because our kids were at private school. We were hemorrhaging because we were in country clubs. We were hemorrhaging because lawyers were swarming around. We were hemorrhaging because we had to go through 2 rounds of mediation. We had depositions. I got to do a deposition. We had multiple discovery requests where I had to go back 5 years to provide every single account.
Objection, Aaron.
And so
Sustain.
I don't know how we.
Well, we can stop at that point. I don't know what your definition of racking up, but he definitely said a lot.
Multiple credit fees.
Well, he said a lot, so you can ask him. I don't know if you want him to continue down that line. Okay, so yeah, ask him the next question.
Did you just say that we were hemorrhaging for private school fees that we had paid the year before, Elliot?
We were spending more money. We were spending more
One
money.
at a time.
We're spending more money than we were making, and so in my opinion, we were hemorrhaging. You and I actually had a schedule where we said that our money balance would continue to go down because we deliberately said we would spend more money than we would make. Because you didn't want to go to Portland, and you wanted to stay in this house because you loved this garden. And so as that balance was down, I'm sorry, but I defined hemorrhage as we're spending more money than we're making.
Did we pay ESC off in 2022, February of 2022?
I'm object to ask and answer because this was. 10
That's
minutes ago.
great, he just brought it up again.
One at a time. One at a time.
Don't perjure yourself. Mr.
Sustain, ask and answer. Ma'am, you only are allowed to ask him questions.
Okay. Did we drop the country club membership, but you just mentioned it again, as if we had a country club expense? We did not. Where did our money go, Mr. Zimmer?
I think I laid out the situation that was at hand. We had a house, where I forget the monthly expenses, but it's probably in all these different schedules. But we had a multi-million-dollar house. We had all the different things that were happening. I paid for an account.
One at
Hold on, you have to allow him to finish his response. Then you can ask.
Telling you. I also paid for an account that you chose to sit there with you and walk you through all this, to sit through mediation with you, not once but twice. And so that they can explain how money works and how all this was happening, what was happening on the budget. So, Michelle, we were spending more money than we were making. And at some point, cash flow.
Sustain.
That came out, I had.
Hold on. No. Questions only.
Did you pay for that account? Or did me and my family pay for that account?
I don't think you and your family paid for that account.
I know for a fact you did not pay for that account.
Just a sidebar.
Sustain.
You mentioned that you this line item. I'm sure it's in the line items. So can I present this now to him since he mentioned it?
It's not in evidence.
Well, he said, I'm sure it's in the line items. This is the line item.
I've wanted to discuss.
You may ask your next question.
I'd also like to reflect that Ms. Chase, who's coming here and said she didn't have time to prepare exhibits, is sitting here with a binder just as thick as ours with a list.
I don't have this, because this is from my attorney from 3 years ago, and I don't have this electronically to provide to them.
Okay, so continue.
So I'm sorry that I had.
Hold on, ma'am. You are out of order.
So, Ms. Chase, for the record, you're confirming you were sitting there with the binder of exhibits that is nearly as thick as the binder that we came today.
This is Lisa Duffy's binder.
These are exhibits that you have brought from the original trial, correct, as you sit here today?
Yes.
Okay.
Your point being?
Here, go ahead.
Okay. So. I want to make it clear. What settlement offers has my side made? I believe Mr. Page said that you guys offered a settlement offer in June. That was a counter offer, wasn't it? Did you make the original settlement offer, or was that a counter offer? How many settlement offers has my side made?
And I ask for, I object to fade because I think we're talking multiple lawsuits.
You lied.
Sustain.
You flat out lied.
That's the last time you will address him.
So,
Excuse me.
I'm sorry.
No, I don't need an apology right now. I need you to understand what I'm saying. That is the last time you address him. That is the last time you interrupt me. You're an attorney, so you're held to the same standard as any other attorney. You know not to speak when anyone else is speaking, ma'am, even when you are representing yourself. Have some candor, okay? Go ahead. Go ahead with the question.
How many settlement has my side made?
Sustain.
Did my attorney make a settlement offer to your attorney, first to New Mexico, last spring?
I'm gonna try to answer and help you out. Sure. As best I can, please. Your attorney in New Mexico offered my attorney a settlement offer on the cabin itself, and I referred to that in my testimony. And that's what I referred to in my settlement offer back to you, and in an email, we had agreed to what we would do with the cabin. I tried to help you out by saying, I'll honor that, because I actually want you to have a place to live. In terms of the settlement offer, since the remand came down, I have received no formal settlement offer for you or your attorneys.
Lindsay Rain, are you aware that my attorney Lindsay Ramus made a settlement offer to Spencer Page?
The only thing I've seen from Lindsay Raines is an email saying that you would not acknowledge and did not want to engage with our settlement offer.
Well, then your attorney might have been.
No, ma'am.
So,
Question.
question,
I'll answer for you.
no,
before you
so
ask
are
the
you
question.
aware that your attorney made a counter offer to my attorney?
No,
Yes. Are you aware that I asked in my settlement offer for our children's bank accounts to be returned to them?
that was all communicated verbally, and I think that that's ludicrous because I don't really even understand what you're talking about.
Our children, they're listed in one of the exhibits, in one of the schedules. Our children had 2 bank accounts, 2 savings accounts. Are you aware that you drained those savings accounts? Are you aware that your children came to me telling me you drained their bank accounts?
Objection calls for hearsay and also that.
Sustain. One question at a time.
Did you use our children's bank accounts for your attorney's fees?
Absolutely not, and I live with our children and we don't talk about bank accounts and those kind of things. Actually, they're doing really well.
Oh, really? Are you aware that the last exhibit I saw with our children's bank accounts, one had $15 in it and the other had 5?
Object to asking him about a document, it's not in evidence.
Sustain.
I have personal knowledge of it. Are you aware of how many times you have sued me?
Objection relevance, I think she's already asked the question.
Sustain.
It goes to our community property.
You may ask the next question. You don't have to tell me anything, ma'am. He's the witness.
Shall
No, sir. Hold on. Wait on the next question.
Are you aware that you were to turn over my car title in March of 2024?
I'm gonna object, I mean, this is based on the property division decree, which as of we sit here today, is not enforcing that. So it's no relevance to this.
Car title.
It's just, can I finish my objection?
Go ahead.
It has no relevance to this court's determination of the division of community property.
Sustain.
Are you aware of the value of my car now that I still don't own?
I would also object relevance to the value of the car right now, because we're dividing that based on value at the time of divorce.
Sustain.
I still don't own a car. Are you aware that I have now had a warning and I issued a citation yesterday because I can't get my car registered because I don't own my car?
There's three different rounds of attorneys. That's, the Spencer trying to figure this issue out for you in Texas. I've offered you a path to get your title in Texas.
I do not live in Texas.
I know that you said
Object
that.
to interrupting his answer once again.
Ma'am, let him finish his answer.
And through your attorney in New Mexico, my attorney's in Mexico, we went back through the paperwork to transfer. And I signed it and notarized and did all the things that were necessary. Since doing all that work, I have not heard anything from you about your car. So whether or not you can take the paperwork that's been signed over to you down to a DMV and get yourself the right documentation is not my issue at this point.
Yes, it is. You have to. Are you aware that you have?
No,
to
ma'am.
sign?
Question.
Are you aware that you have to sign and send by snail mail? You have to notarize and hand sign. New Mexico will not accept copies. And that was, are you aware that your attorney provided that information to you?
I signed and notarized everything that I've been told to sign and notarize and all.
Emailed it. That is not acceptable in New Mexico.
But the
Are
attorney.
you aware that this was? you were notified of
Question.
this in May?
Question.
Are you aware that you were notified of this in May? And still have not complied? You were to turn over that car title as of court orders on March 7th of 2024.
This is a great example. This is a great.
Hold on, Mr. Zimmer.
I object to Tom, and again, and also for the record, Ms. Chase, not only is she an attorney, but she has been instructed by this court multiple times today on how this is supposed to work and refuses to comply with the court's instructions.
I'm sorry, did I mess up again?
Almost
You may-
every single question.
You may ask your next question. You have 8 minutes and 52 seconds left. Attorney Page, you have 21 minutes and 3 seconds
I'm
left.
done.
Okay. Attorney Page, any redirect?
Just very briefly, Judge.
Go ahead.
So Elliot, on the Walnut Hill house, you said that house was pending for about 2 months, as far as you recall, before it sold.
Yes,
Do you believe that the value you sold before was fair market value?
yes.
Okay, it's 2 months of that, I mean, that wasn't a fire sale, was it?
No, it was not.
That wasn't a what?
Fire sale? And when you're looking at, when she asked you about P15, which was the Zillow screenshot,
Yes,
to understand, would you agree with me that a Zillow estimate or this estimate, as they call it, is not a professional appraisal? Correct. Would you also agree that any sort of estimate is exactly that, just an estimate of fair market value?
correct. There were many issues inside the house that were aging and so on and so forth. And so you get professional realtors and you get appraisers and you get everybody involved in the sale of the house. And you can't sell a, it gets very difficult to sell a house that it can't appraise for, what it's being sold for.
Okay, and just to make it abundantly clear, because there was a number of questions about allegations about stolen community property. Have you stolen any community property?
No,
Have you stolen any money from your office?
no,
Have you done anything, as far as you're aware, done anything to violate the standards?
No.
Okay, that's the.
Okay, anything further from Mr. Zimmer? Ms. Chase? Okay, all right, Mr. Zimmer, you may return to your seat. Attorney Page, you may ask call your next witness.
Thank you, Judge. I would call myself just briefly for attorney's fees.
Okay, you may proceed.
Judge, this is already in evidence, but just so that the court is aware, our exhibits. Um. 79 is a summary of the attorney's fees that Mr. Zimmer has incurred since sending the settlement offer over to Ms. Chase that she rejected. We've got every single redacted invoice that shows the expenses. We've got unredacted copies for the court to view in camera if the court so desires. As we sit here today, Ms. Chase has, not only has she frustrated the court's instructions even today, but she's frustrated the court's instruction throughout this process. As we put on record earlier, she's sitting here with a binder full of what looks like dozens and dozens of exhibits, and yet she told Judge Lee that she couldn't be here in the morning, she didn't have time to prepare exhibits. She told you this morning that she didn't have time to prepare exhibits, and that's absolutely not the case. Mr. Zimmer has gone above and beyond, even yesterday, with us filing a last minute response to her mandating us for something that should have been very simple. The Court of Appeals gave an instruction on performance units. We could have easily accomplished this without needing to get the court involved. We come back here, and yet she refused to do that. And as you can tell by her demeanor today, she refuses to cooperate with anything going forward. So we are asking that she be required to pay this attorney's fees. 80 is that settlement offer we sent over. And then 81, P81 is my affidavit in support of our request for attorney's fees. If I line by line on that affidavit, it would summarize everything that all of my testimony as it relates to attorney's fees and reasonableness and necessity. So, Judge, we're asking for in addition to the property division, we're asking for a judgment in the amount of $23,325 for attorney's fees that Mr. Zimmer's incurred in relation to this building. And with that, I'll pass myself as a witness.
All right. Ms. Chase, you may ask Mr. Page or Attorney Page any questions you have about his testimony.
I again state that we're the ones that sent over the settlement offer.
Do you have any questions for him?
I mean, did my attorney or did my attorney not send over the initial settlement offer?
Not the initial settlement offer, no, the attorney did send a settlement offer that Mr. Zimmer testified about and wanted, I want to say it was $200,000 to $300,000 that you alleged that was stolen out of the estate.
No, that's not.
It's a number. Let me finish my answer. There's a number of things in there that were not supported by the evidence. The court didn't rule upon last time, stuff you didn't even ask for at trial last time. And your attorney conveyed to me, she wanted to try to get a settle. So we sent her a settlement offer that was, frankly, in my opinion, and all of Mr. Zimmer's settlement offers that sent a number of cases been very reasonable to you, favorable to you, and less favorable to him, trying to get this done with, and you rejected that.
I'm sorry, can I clarify something?
You can clarify the question you're asking him.
I actually have a legal question.
I can't give legal advice, ma'am.
I know that settlement offers were relevant in court. I did not believe that you could bring settlement offers into court. I thought that was illegal.
Do you have a question? Sustain. You have to ask him a question.
Is it legal to bring a settlement offer into court proceedings?
This is the first I've had to make an objection, but I would object that I can't give her legal advice because I don't represent her.
Sustain.
I'm gonna object to him bringing the settlement offer.
What's your legal objection?
The legal objection is, I'm just gonna say it's hearsay.
Judge, it's for,
Response.
yeah, Judge, a couple of things. One would be that it's already in evidence. Judge Lee, Mr. Zimmer, and myself and his court waited from 8:30 this morning till 10 o'clock this morning for Ms. Chase to show up and be at the exhibit conference, which she decided not to show up to. But she did make her objection at that time. She did make the objection at the beginning of this trial when you admitted our exhibits and evidence. And on top of that, it is a settlement offer for the purposes of attorney's fees. There's a case, Lawrence v. Bowles, that allows the court to consider settlement offers for that sole purpose, and that's why we used it today. So it is a.
Okay.
Overrule.
I'd like to make clarification.
You can ask your next question.
Do you recognize the email from this morning Monday, July 20th. From last night. Trial with Judge Bailey.
I'm objecting to the extent this is something that's not in evidence.
Well, it's, you all mentioned it. You all.
Are you referring to 82 or 83?
I am referring to an email that was sent this morning that clearly says that trial was to begin at 9 AM and that there would be a conference at 8:30 AM. This email nowhere states that trial today would start at 10 and that I would have time to.
Okay, you're here. You were here timely. You got here before 10 AM, so you can ask him the next question because that's not relevant. You may ask him the next question.
Conference this morning that I was given more time to prepare for. Did the judge say that trial wouldn't start until 10 AM?
So, yeah, so P82 and P83, which were both in evidence.
I don't know those.
If I can finish my testimony. P82 and 83 were both in evidence. Judge Lee responded because he refused to have a conference yesterday by Zoom. So if you refuse to have one.
And why couldn't-
I think-
Why?
I think my testimony. You asked a question and I'd like to answer your question. She offered you the ability to do it by Zoom during the day yesterday. She offered you to do it by Zoom after hours. She was willing to stay after hours and give you the time so you could do a conference by Zoom last night. Or she was willing to have an in-person conference this morning at 8:30. She gave multiple offers to you. Frankly, I think Judge Lee did more than she's required to give you the opportunity to be present to participate. And then she confirmed, there's emails in, it's either 82 or 83, where she says that we can do the conference today at 8:30, and she can talk to Judge Bailey about it, with trial starting at 10 today. And you decided that you didn't want to show up at 8:30, whether trial here today starts at 9 o'clock or 10 o'clock makes no difference, because we waited from 8:30 to 10 at the conference to see if you'd show up. And then we're here today, just like Judge Bailey said, you were here, you were participating in this case, and we haven't defaulted you for being late.
May I please, do I have a chance to speak now?
You have another, you want to ask him another question?
I'd like to call myself as a witness.
Okay, so he's still the witness right now.
I have no more questions.
Judge, I'll pass myself as a witness.
Okay.
And I was going to watch her next, but if she wants to, I'm fine taking her out of order. If she wants to do her direct through the last 8 minutes or 6 or however she's got.
Oh, no. Yeah. Which do you prefer? Do you prefer to call yourself as a witness first? Okay. And you're resting, just so the record is clear.
I'm not, I would still like to use my time to cross-examine her to get it closed.
Okay, okay.
Yes. And I guess if I need to recall my client. If the court would prefer, I can do it. I can cross her first and then she can redirect herself. Whatever you prefer, Judge.
No, she wants to speak, so
That's fine.
yes, ma'am.
May I? This notes. Or is that not allowed? I'm not sure how that works.
I'd object to that one. It's got notes on.
Yeah, you can take a blank sheet of paper.
Okay.
I can give you the cover sheets.
Okay, would you like to start by crossing me, Spencer, or?
Well, you're,
And then I'll cross.
Yeah.
So
you just start speaking about, all the extra that at the end of each question, when you were speaking, you can speak about that.
if I can remember. Thank you, though. Okay, so. First, I want to start out, I have not seen any email stating that trial was gonna start at 10. I was here at 9 o'clock. I sat outside with my mother. We asked some people what was going on and they said that trial wasn't starting.
Objection, hearsay.
Sustain,
Well, I was told trial wasn't starting until.
Objection, hearsay.
sustain.
No email. I drove 9 hours yesterday. I've been sick. I have filed motions. It was done on Wednesday. Judge Lee said that we were going to set a conference, for Thursday afternoon. I requested a time, Zoom information verification on the conference.
Objected, relevance, like whether times happened Thursday or not.
Sustain.
We have been talking about it when I was this morning. I provided myself for a conference on Thursday that never happened.
Ma'am, we're beyond that. Do you want me to hear what you have to say about your property or no?
I'm sorry, he's been able to get all the information about the conference yesterday and today into evidence. Why can't I get the conference that I've made myself available to attend? It's been 24 hours
Thank you,
making
Counsel.
myself available to attend. It never occurred. I don't understand. I can't seem to get anything on record.
You may,
I have not
you may
been-
proceed.
Okay,
You may not proceed with talking about whether you appeared at a conference or not. That does not matter. We're here at trial. We're here at trial.
yes, and I'm explaining why I didn't have time. So
You know what? If you choose to waste your time like that, we can go ahead. Keep talking about the exhibit conference. Go ahead.
I've made myself available at every avenue that I possibly can. I had to travel 9 hours yesterday. Mr. Page expected me to pull over somewhere in East New Mexico, West Texas, where I got no reception, and make my car available as a workspace for an evidentiary conference. I'm sorry, to me that seems not only unfeasible, but unreasonable. I got in last night to Arlington, Texas. I did the best that I could, pulling notebooks, pulling whatever I could to try to create some sort of an argument today. The notice of the hearing came in 2 weeks ago. This is a multi-million-dollar estate.
To the relevance, and also I have no notice that there was a motion for continuance on file today. I believe the court's already ruled on that, so I object to her going into the stuff.
Sustain.
You have no notice of a motion for continuance?
I have absolutely zero notice that there's a motion for continuance set for trial today.
Oh, no, I'm not saying that.
Okay, so then I object to relevance because it's not due to anything that's said before.
Sustain.
I'm saying I've worked the best that I can.
Okay, are you speaking now or are you talking to him?
I'm speaking now. So
Okay, go ahead.
Again, the 2-week notice that I've had, to try to prepare for a multi-million-dollar remand of a complete property division. I don't know what else I can do. I just know what I'm missing, and I have once again had no time for a forensic audit, which I had requested before the original trial, which was expedited as well. So once again, I'm in a situation where I have no idea where 24 years worth of property has gone. I can only say that I know for a fact we did not have a country club membership that Mr. Zimmer referenced again today. We did not pay $200 a month or a month in lunches for our children. That was paid in tuition, which was paid the year before. As Mr. Zimmer stated, we paid tuition the year before the previous, the school year, the upcoming school year. I'm asking, he said that there's no way we can recreate the community estate, and I am saying that there is.
Okay, so make an objection.
Go ahead.
I would object that mischaracterized Mr. Tim's test.
Sustain.
I believe it was said that it would be near impossible to create a community estate. And I am saying that I believe it is not. I just had requested more time to be able to do it, as I had in the original trial. If you look at their spreadsheet, a lot of their spreadsheet has TBD, to be determined. That means even they at this point don't know how much things are worth. And all I'm requesting is a little bit more time to do due diligence to try to figure
I
out.
object that that is not a request set for hearing today. I certainly don't have notice that that would be set today, so object to that.
Sustain. You have 48 seconds left.
I have nothing more to say.
Okay, Attorney Page.
Thank you, Judge. So you said that you did not have, you said you had 2 weeks notice today, correct?
That's correct.
You agreed that the appellate opinion came down in March of this year, correct?
The mandate came in July 15th.
It was that when the mandate came down and said that we were remanded, was that a surprise? Was it the first time you heard that the case was being remanded?
It was the first time that I knew that, it was going back to trial.
Okay, so when the appellate opinion that came out in March said it's coming back to trial, you thought the Court of Appeals was lying to you?
No, I just knew I couldn't get discovery at that time. And my understanding is I can't get discovery until the mandate
Objection,
comes in and sends it back to trial.
Sustain.
Objection on the budget. You also, you're talking about property, you've made a lot of allegations about property over a 24-year marriage. You agree that you had I mean, before the remand, we had an entire divorce case where you did discovery, correct?
I was not able to have a forensic audit done because of the expedited trial.
Objection non-responsive.
Sustain.
You did discovery in the divorce, correct?
Minimal,
And when you did written discovery, you sent a request for documents, right?
yes.
And Mr. Zimmerman provided some documents, correct?
Some, not all,
Objection non-responsive after some.
Sustain.
And then you filed at least one motion to compel, correct?
yes.
And we had a hearing on motion to compel and agreed to produce additional documents, is that correct?
And you did not.
Okay, objection non-responsive.
Sustain.
You agree, we had a hearing on motion to compel, correct?
Yes,
And you asked the court initially to continue trial during the divorce, right? It was initially set for February of 2024.
yes.
And then the court granted your continuance and reset it to March of 2024, correct?
It was about 7 days. We got a 5 to 7 day continuance.
Okay, you understand that when you went forward to trial, March 7th of 2024, you did not ask for a continuance that day, did you?
We asked for some, we fought for a continuance.
You did not fight for, you did not have any motion of continuance set for trial on March 7th, did you?
Yeah, we were not granted another continuance.
I'm gonna, Judge, I ask the court stage judge to notice the court's file.
The court takes judicial notice of all contents of the court's file.
And, what do you think you don't know what the value of the form machines is right now, right?
You don't know what's, slow down, Mr. Page, and you don't know what the value of what is?
The value of the performance is right now. You also, going through the assets awarded to you, you got, several $100,000 from the sale of the Dallas zone, right?
My attorneys did.
So you're telling this court, you didn't get any money out of the sale of the Dallas house.
I can provide the documentation. I got very little because I had to pay attorney's fees out of my settlement.
Not what I'm asking you.
Well, okay. Then rephrase your question.
Okay, well, my question was phrased correctly. You got several $100,000 out of the sale of the Dallas house,
I
correct?
did not.
You were supposed to get, before any net was taken out, you're supposed to get in excess of $450,000, right?
I'm not sure because I didn't see it.
So you're telling the court that you didn't, but you also have no idea how much you got.
There was a list pendants on my home, so I did not see the full amount that I received.
I'll ask you another way. You don't have any of the proceeds left anymore, right?
No,
You spent them all.
on attorney's fees, we said and sued 8 times.
Well, first off, let's talk about the attorney's fees. So there's an enforcement filed because you didn't sell New Mexico residence, right?
The New Mexico resident.
Objection non-responsive.
Sustain.
Ms. Chase, I'm asking you very simple questions. There was an enforcement filed because you didn't sell New Mexico residence, correct?
No,
Okay, so you're telling this court and this consider myself that there was not an enforcement before this court in 2025 because you didn't sell New Mexico residence.
it was up for sale.
Objection non-responsive.
Sustain.
I'm sorry, I don't know what you're saying. I have no idea what you're saying because I followed the letter of the law to the nth degree.
That's very clear from your activities today, Ms. Chase. You agree with me that the house is still not sold 2.5 years later, right?
That is
And
correct.
you're still living in the house today,
I
correct?
am, and it's still for sale.
Okay, and you've not got a buyer in 2.5 years.
We've had a lot of people looking.
You agree with me that you benefit from staying in the house, right?
Yeah.
Okay, and so you don't believe motivation wouldn't be there for you to sell the house. You're better off if it's not sold, right?
No, that's not the case because do I want to live
Objection.
in across New Mexico?
Objection non-responsive after that.
Sustain.
And in fact, one of the issues you appealed from this court's ruling was the court's order that the house be sold, right?
Yes.
Because you want to stay living there.
Because I want to get him out from under that property.
So you just don't want him to have his share of that property?
I want to sell the Firecroft home for 16% less than taxable value, similar to what he sold our Dallas home for.
Okay, but you haven't even tried to do that, right? It's not.
Yes, that has been in our settlement.
It's, you said, you testified to this court that it's listed today, right?
Yes.
Is it listed 16% below taxable value?
No, it's listed for
Objection
just,
responsive after no.
Sustain.
You agreed there's an agreement to split the estate 55-45, right?
yes,
Okay. And when you say that there was a lot of money that was mishandled in the estate, we had a trial March 7, 2024, right?
yes,
Okay. And you presented some evidence of some waste claims that you had at the time, right?
that is correct.
Okay. The court didn't grant you waste claims, right?
That's correct.
Okay. And you didn't appeal that part of the ruling at all, did you?
We objected.
Objection unresponsive.
Sustain.
You filed a notice of appeal with the Fifth District Court of Appeals, correct?
That's correct.
And waste claims were no part of that.
Equalization of attorney's fees and waste claims we objected to, so that is part of the property remand.
Sustain.
Not my question, Ms. Chase. And again, you're an attorney, right?
I must not understand what you're asking.
Okay, I just asked you, you're an attorney, right?
Yes,
Okay. And so you've gone through law school, right?
yes,
Your years work today, correct?
Your what?
Years work today,
Your ears work to me.
correct?
yours work today?
Mhm.
Yes,
And so you've heard Judge Bailey give you instructions throughout this trial, correct?
yes,
And you also would agree that you've willfully disregarded those at almost every juncture today.
no, not intentionally.
Okay, so you would agree that you have disregarded throughout the entirety of today's.
No, I've explained that this is the first time I've ever represented myself in litigation or been in litigation, and so I'm sorry if my etiquette is lacking.
Okay, today is the first time you've been in litigation, Ms. Chase?
Yes, I mean, the first time I've ever represented myself or anybody in litigation.
Okay, so but you've been in front of this court on, this is now at least your third occasion in front of Judge Bailey.
This is the second time I've been in person in a courtroom.
Okay, and the third time you've been in front of Judge Bailey alone, right? Actually, maybe the fourth time as well.
I'm not sure.
Okay, and you've been in front of Judge Lee a number of times over the last
That's
3 years, okay? And evidentiary hearings, right?
I don't think so.
Okay, so you don't agree that you were part of a temporary orders hearing at some time?
Yes, yes,
In fact, you've
but I
been part
didn't
of,
know that was an evidentiary hearing.
there's evidence anyway.
Yeah.
Okay, and in fact, you've been part of multiple temporary orders hearings.
Slow down, Mr. Page, and in fact, what?
You've been a part of multiple temporary orders hearings.
I've been a part of one temporary orders hearing.
So you had a divorce with a temporary orders hearing.
Yes, yes,
And then in the modification, we had a temporary orders hearing.
yes. I'm sorry, objection relevance.
Judge, I'm just trying to establish that she knows exactly what's going on. She's been complaining left and right, not only to you, Judge Bailey, but to the Court of Appeals, and she's got no idea that she's a single mother who doesn't know how to do any of this stuff, and it's absolutely not true. And I think it is relevant to the fact that she's disregarded your instructions today. I presume she's gonna make arguments to the Court of Appeals in the future that she doesn't know what she's doing again. I think it's important to record show that she is an intelligent woman and she knows exactly what's going on. And she's had a lot of experience in litigation, much more than most people have going through this process.
I'm sustaining her objection. Were you trying to make an offer of proof?
I will make an offer of proof to the extent the question's already in the records. Well, present those as an offer of proof.
Okay, thank you.
Thank you, Judge.
You're welcome.
So you testified, you've been available at every opportunity in this case.
No, I haven't. I had leadership Firecroft on Friday. I made myself available Thursday afternoon and I've tried to make myself available as often as possible. And I've tried to work on everything as diligently as I can. But unfortunately, I did have to drive 9 hours yesterday. And most of that time I am out of range. There's no, even in Abilene, like you're still spotty after Abilene, but no, you typically do not have great cell phone range. And there was no way I could make myself available. And then unfortunately this morning, I really
Objection
honestly.
made at this point.
Sustain.
So, Ms. Chase, and I'll represent you, but I've not only been myself to clarify the law around West Texas there. So it's your testimony under oath right now that the entirety of the way it needs to Abilene, you have no cell service.
It's very sketchy. Yes, my attorney tried to call me yesterday and I lost her. So yeah,
Everyone in Midland, Odessa just doesn't call people on.
that's not the way you go.
Okay, so everyone in any town along the way does need cell service.
It is very limited. And that's legit. You even have to download podcasts before you go.
And you, what time did you get in last night?
I got in yesterday around 4 o'clock.
And so you agreed, Judge Lee offered to have a Zoom conference after hours with you.
I didn't have time to prepare. I'm sorry. As you can see, I don't have exhibits. I honestly did not have time to go through 85
Ms.
of
Chase,
your exhibits.
are these exhibits that I'm looking
I
at?
don't have those electronically. That was literally something I pulled out before leaving from my bookshelf in my laundry area that I have not looked at in years and tried to go through it last night to figure stuff out. I mean, I'm
Object to narrative at this point, Judge.
Sustain.
And well, you got our exhibits on Thursday morning last week, right?
I did, and
Objection or response to that, right? There.
Sustain.
And you're not employed right now, right?
I'm representing a client, but no, not really.
Okay, and you've not really been employed for at least 3 years at this point, right?
2.5 probably. I ran a nonprofit for 15 years.
Okay, and but you agree that's not full-time employment, right?
No,
Okay, so you don't screw my client's an executive company, right?
oh yes,
And we had time to prepare exhibits, right?
he has a full legal team.
Okay, and you're a licensed attorney without employment, right?
I am not a family law attorney. Thank God.
Just don't pass the witness this one.
Okay.
Okay, so.
You have 45 seconds.
Okay, wonderful. Well, I apologize again for not knowing the proper etiquette. I mean, I honestly have tried. I wish I knew objections, and next time I am in court, if I am again, I will first and foremost memorize objections. And I do want to clarify one thing. I have never tried to go against this court. I 100% tried to get Mr. Zimmer to sign an addendum. The cloud cost resident, I was not on the deed, and it was an illegal impossibility for me to get that home on the market. The realtors would not sign the agreement because I was not on the deed. The minute I was put on the deed, he would not sign the addendum. Yet the minute I was put on the deed, on that property up for sale.
Okay, ma'am, you just ran out of time. Okay. Did you have any other questions for Ms. Chase?
Can I get a time check real quick, please?
You have 5 minutes and 1 second left.
Okay, I will ask a few questions.
Okay.
Ms. Chase, is there any sum of financial funds that you were awarded in the divorce that you have as we sit here today?
Yes. I want to say about $45,000.
From which account was that awarded to you from?
That's just that's where I put the money that I have.
Okay, and that was, you agree with me that was substantially less? Like, I don't put you on the exact percentage, but definitely less than half of what she got out of the divorce, right?
Yeah.
Okay, so if Judge Bailey were to divide things differently today as far as financial accounts, you wouldn't even have the money to pay to Mr. Zimmer to offset things like that, right?
I would take out one.
Okay.
So, yeah.
Even with no income, you'd be able to take out a loan for whatever judgment the court would put in place?
Yes.
Alright.
I mean, yeah, so if I have to buy my home, then I'll take out a loan to do it.
Okay, and you agree that 45,000, that's enough to pay for the attorney's fees that we're asking today, correct?
I'm sorry, I won the remand. I won the appeal.
Objection, not response.
Sustain.
Lovely.
You agree that that's enough money to pay the attorney's fees we're asking today, correct?
No, I don't. I've got a $25,000 debt from attorney's fees from your lawsuit for me.
Okay, so, Not my question. You said $45,000?
It was a $25,000 debt that I'm gonna pay.
Okay, well, you haven't paid yet, right?
I'm about to,
Okay, well,
credit card debt.
so you don't know an attorney. Okay. Correct.
I'm sorry,
You don't owe an attorney any of that money, correct?
it's from, I actually do owe an attorney $20,000, so yes.
Okay, so, because I'm asking you a number of questions and you've given me now like 3 different answers.
Well-
Do you,
What is this, what's the relevance of this, Spencer?
we are dividing up your estate. No, I don't even,
Okay.
Objection.
this is My current estate, let's talk about Mr. Zimmer's finances.
I didn't, excuse me, Ms. Chase, I didn't get your objection.
my objection is her asking.
What's the legal objection?
Well, I guess it's legally improper that it's not responsible. She's not
Sustain.
responsible for the question. And I guess I'll pass to the judge. I'll save the rest of my time for closing.
Okay, Ms. Chase, you may return to your seat. You're out of time. Attorney Page, you can go ahead and close.
So Judge, I think you've obviously seen a lot today. We're here on one question, which is the property division as of the date of divorce, which is where we've got to value all the property. I think obviously, Judge, you've got a lot of discretion, as you know, to divide the property in any manner that we see fit. Just from my client's own request, we ask that we don't change the property division up too much. I think you've seen just by the way Ms. Chase has acted today, that if we try to like reverse engineer the property division too much at this point, it's gonna be an absolute disaster. And we're gonna have to get attorneys involved, maybe across state lines to get that stuff resolved. My client and Ms. Chase agreed to a 55-45 split. Technically, the division is a little more in Ms. Chase's favor. My client's not objecting to that. He just wants to be done. He's tired of going through litigation with Ms. Chase. He's tired of spending attorney's fees on this. And I understand why that's the case. So we're asking, I don't think she can complain about getting more than what she bargained for either. So in an effort to minimize costs for both of them, to do what the Court of Appeals has brought us back down to do, and to prevent any sort of, I'm sure she's gonna try to appeal in the future to prevent any sort of appeal. We're asking them to just keep that property division we have attached to our exhibit 1. And as part of that, not change up the Cloudcroft sale or the split, but 100% give Mr. Zimmer the ability to make that sale, to make the decisions, get Ms. Chase out of that house. Because it is ridiculous that we're 2.5 years later and Ms. Chase is getting up here with a straight face and trying to say that she's done everything possible to get this thing sold. I get that rural New Mexico houses aren't going to sell as fast as houses in Dallas. They also going to take 2.5 years. They take that when you have a property listed way above fair market value. We actually had a hearing judge in front of you in 2025, if you recall, where we had an ex-witness who's a realtor in the area.
Slow down.
We had an expert witness who is a realtor in the area, and she testified that she literally would not bring her clients by the property. She was aware of the property. She wouldn't bring them by because it was so above fair market value. She couldn't recommend that to anyone.
Objection, hearsay.
The judge, this is closing, so it's not for evidence or value. We're asking the performance units to split 55-45. And that's really the crux of what we're asking in the forced attorney's fees. Judge, I think you've seen what we've been dealing with this many years.
Thank you, counsel. You're out of time.
Thank you.
Okay, so as far as the exhibits that I have looked over thus far, I'm only up to and I mean, I know you all referenced them, but in terms of like giving it a deep dive, I'm only up to like 60. So the court needs some time to review 61 through 83 and to review some things that I took notes on for the transcript. And I'll have you all a ruling. I should be able to get your ruling out by Thursday.
Perfect.
Yeah.
Thank you, Judge.
Thank you.
us briefing or anything like that, obviously feel free to reach out to us and we're glad to provide whatever it is.
Yes, thank
Have
you.
any questions that you need?
We're off the record.
Anything, please, hope this has.
Yes, ma'am.
The heart of the remand is a single class of asset, the performance units Mr. Zimmer received from his former employer, Oregon Tool. The petitioner calls a CPA, Mr. Rice, as a financial expert, and his testimony explains why the appellate court singled these units out. Under the Texas Family Code, property possessed by either spouse during or on dissolution of marriage is presumed to be community property under Section 3.003, and the trial court must divide the community estate in a manner it deems just and right. Under Section 7.001, performance units acquired through employment during the marriage fall within that community estate. The difficulty is valuation. The expert testifies that these units are akin to a cousin of stock options and have no ascertainable fair market value because they pay out only upon a defined triggering event, a sale of the company, an IPO, or a cash distribution to equity holders, none of which has occurred, with no way to predict whether or when any will. Texas courts have long grappled with dividing contingent, unvested, or unascertainable employment benefits, and the accepted solution where present value cannot be determined is to divide the asset in kind on a deferred basis, awarding each spouse a fractional share to be received if, as, and when the benefit is ever realized, an approach Texas appellate courts have applied to stock options and similar interests, as illustrated by cases such as Bowden v. Bowden, 955 S. W.2d, 380, Texas App. San Antonio 1997. That is exactly the relief sought. A 55/45 split of the units themselves rather than a present cash valuation. The units also carry an expiration date of December 31st, 2028, which underscores why a share of the asset division, rather than a dollar figure, is the workable path. The hearing closes on 3 requests, and the reasoning that will govern the coming ruling is worth drawing out. First, on the overall division, the petitioner asks the court to largely re-enter its prior division at the agreed 55/45 split, changing only the performance unit allocation and updating 2 values to reflect events since the first trial. This reflects a feature of Texas remand law that recurs throughout the hearing. When an appellate court finds reversible error in any part of a property division, it must remand the entire community estate, because the just and right division under Family Code Section 7.001 is an integrated whole. The Texas Supreme Court established this in Jacobs v. Jacobs, 687 S.W.2d, 731, Texas 1985. That is why the respondent is technically correct that the entire property division was remanded, yet the trial court retains broad discretion to reach substantially the same result where the only identified error was the treatment of the performance units. Second, on the New Mexico residence, the court is asked to give the petitioner sole control of a sale that has stalled for 2.5 years, a practical enforcement problem, distinct from the community characterization question the mandate addresses, which is why so many of the respondents' questions about car titles, credit cards, and standing orders draw sustained objections as matters for a separate enforcement action rather than this valuation trial. Third, attorney's fees. The petitioner offers a rejected settlement offer in support of a fee request, and when the respondent objects, opposing counsel invokes case authority permitting a court to consider settlement offers for the limited purpose of assessing attorney's fees. The general rule is that settlement communications are inadmissible to prove liability under Texas Rule of Evidence 408, but that rule expressly permits their use for other purposes, and Texas courts have allowed offers in for the narrow question of the reasonableness of fees. The judge overrules the objection on that limited basis. The broader lesson for our audience is one about the difference between winning an appeal and controlling what happens next. A remand does not reopen everything a litigant wishes to relitigate. It returns the case to the trial court to correct the specific error within the framework the appellate court set. A party who treats the retrial as a fresh chance to prove waste claims, hidden accounts, or misconduct that was, or could have been, litigated the first time will find those doors closed by objections grounded in scope, relevance, and the rules of evidence. regardless of how strongly she believes she was wronged. And representing yourself, even as a licensed attorney unfamiliar with family practice, does not lower the bar. The same procedural rules, the same evidentiary predicate for admitting documents, and the same requirement to ask questions rather than testify apply to everyone. The hard truth running through this hearing is that a favorable appellate opinion is a mandate to fix a defined problem, not a mandate to start over. And the litigant who spends her limited trial time re-arguing settled issues rather than building an evidentiary record on the one issue actually remanded risks losing the narrow ground the appeal had won her.